What happens to retirement accounts and pensions in a Chicago divorce? When couples divorce in Chicago, retirement accounts and pensions earned during marriage become a critical financial battleground. Under the Illinois Marriage and Dissolution of Marriage Act, any portion of a retirement account or pension earned during the marriage is marital property. This classification applies regardless of whose name appears on the account or which spouse contributed the income. However, not every dollar in your retirement account will be subject to division in your divorce. Pre-marital contributions, inherited accounts, and properly documented separate property may remain protected from division. The critical dates are the date of marriage and the judgment of dissolution or legal separation. Contributions made before the marriage are generally non-marital, while contributions and pension accruals during the marriage are generally marital property. For example, if you opened a 401k 5 years before your marriage and contributed for 15 years during the marriage, the premarital balance may be classified as non-marital. However, the contributions made during the 15 years of marriage, along with employer matches and investment gains on those contributions, are marital property subject to division. A premarital retirement account does not automatically become marital property, but the burden of proof falls on the spouse claiming non-marital status. You must be able to trace and document the premarital balance clearly with account statements from before the marriage and contribution records. Commingling is a common risk where marital and non-marital funds are mixed in the same account over many years. Without proper documentation, a court may treat the entire account as marital property subject to division. Illinois follows equitable distribution, which means the court divides marital property fairly, but not necessarily in half. The Illinois Marriage and Dissolution of Marriage Act directs courts to consider several factors when dividing marital property. These factors include the length of the marriage, each spouse's economic circumstances and earning capacity, age, health, and employability. Courts also consider contributions to the marital estate, including homemaking and childcare, any dissipation of marital assets, and tax consequences. In a long marriage where both spouses have similar income, the division may approach 50-50. In a shorter marriage, or one where economic circumstances differ substantially, the split may look quite different. Spouses can agree to divide retirement assets and all other marital property through a marital settlement agreement. This approach is often preferable because it gives both parties more control over the outcome than leaving the decision to a judge. For example, one spouse might agree to give up their share of the other spouse's pension in exchange for a larger share of the home equity. Nearly every type of retirement account can be subject to division, but the method depends on the type of plan. 401k and 403b plans require a qualified domestic relations order, while traditional and Roth IRAs use direct trustee-to-trustee transfers. Illinois government pensions require a specialized order called a QILDRO under Illinois statute, while military retirement follows federal uniformed services rules. Private employer pensions can be divided through present value buyouts or shared payments at retirement. Protecting your retirement assets during divorce requires experienced legal guidance from a lawyer who understands Illinois property division law. Call Caesar and Bender, LLP at 312-236-1500, located at 150 North Michigan Avenue, 2130, Chicago, Illinois 60601, to discuss how retirement accounts and pensions may be divided in your Chicago divorce.